Good afternoon. My name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GC subcontractors and suppliers. We are a national construction document service. Today, we have a great webinar on what happens after I record my lien, how do I get paid, by construction lien law experts Daniel Weidner and Taylor Hayes. Without further ado, I would like to introduce Daniel and Taylor.
Hello, everyone. I'm Dan Weidner, and this is my colleague, Taylor Hayes. We work at Cooley Justice in Omaha, Nebraska. I chair our construction industry practice group, and Taylor is one of our associates in our practice area that is instrumental in helping us with all construction matters. We handle everything construction related, but one of the areas that we spend a fair amount of time on is helping our clients ensure that they're getting paid for the hard work that they do, because we all know that we prefer to get paid for the work that we do. Today, we're going to spend some time walking you through what happens after we record our construction liens and how do we ensure that we get paid. There is a question and answer box in the chat that you can feel free to post any questions, and we'd be happy to take those questions at the end of our presentation. So without further ado, we're going to kind of talk about the lien process, and in understanding what happens after recording your lien actually starts with what happens before you've recorded your lien. Ultimately, just because you've recorded a lien does not mean you have an enforceable lien. In the state of Nebraska, you can record a lien at the Register of Deeds, and the Register of Deeds will essentially just record it for you, and they'll put it on record. But that does not mean in any way, shape, or form that it's enforceable. As such, our contractors who are going to record liens need to ensure that they have an understanding of the lien recording requirements. Step one is ensuring that you have a timely recorded lien. The timing to record a lien under Nebraska law is 120 days from the date materials or labor were last furnished for the property. And that has to be substantive furnishing of materials and labor, meaning that it can't simply be the tightening of a screw or something nominal performed to the job site. It needs to be substantive material or labor performed. The next obligation is to ensure that the construction lien is properly describing the property that it's being recorded against. This means that you need a proper legal description so that when it's filed with the Register of Deeds, that the lien actually shows up on the parcel of land that you intended for the lien to encumber. The next requirement is that SunRay, would you be able to mute your line, please? We're hearing a lot of the clicking of the keyboard and feedback associated with that. The next obligation is that the lien must be filed in association with a real estate improvement contract. A real estate improvement contract is a contract to provide materials or labor to make a change in real property or a structure associated with that real property. So in that vein, let's quickly go through what counts. What counts is an alteration of the surface, which can be a change in a stream, filling in a ditch, installing or removing something such as a lake. It can be construction either above ground or below ground. It can be something like the demolition of a building, repair or remodeling done inside the building. Something such as seeding or sodding or other landscaping will also qualify. And then Nebraska is unique compared to some other states in that the preparation of architectural plans or engineering plans, whether or not they're actually used for the actual site, can also be the basis for recording a lien. Now, with the understanding of what counts, let's quickly address what doesn't count. What doesn't count is financing. The mere fact that you finance a construction project does not give you the ability to record a construction lien. Items such as mining, removal of soil, or removal of sand do not count, because items where the intended benefit of removing whatever we're removing from the real property is to subsequently sell that for a monetary gain cannot be the basis for a construction lien. In that same vein, harvesting crops or other farming activities would not qualify. So after understanding what it requires to have an enforceable lien, you need to have an understanding of your notice requirements. And so when you're understanding your notice requirements, it's incredibly important to first understand, are you performing work on residential property or commercial property? The reason that this is important is that a residential property gives the owners of that property certain additional rights that they would not otherwise have under Nebraska construction lien statutes. These additional rights are afforded to individuals who are considered a protected party. And in Nebraska, a protected party is an individual who contracts to give a real estate security interest in property, or they're buying or improving residential real estate if they intend to occupy that. In layman's terms, what that really means is a homeowner who has a mortgage on a property or who has a construction loan and they're benefiting the real property for purposes of actually living there is a protected party. With respect to protected parties, they have additional notice rights. First, during the construction project, there is the notice of intent to file a lien that should be served on a protected party if you're a subcontractor. The reason subcontractors should serve this on a residential homeowner is that any payment that would be made from a homeowner to a general contractor will reduce the lien rights of any subcontractor who would be receiving payment through that general contractor if it's made, the payment is made prior to the notice of intent to file a lien. If that notice of intent to file a lien is provided prior to the payment, then the payment that is made to that general contractor does not reduce the value of the lien, and there's still an opportunity to record that lien even if the GC was paid in full. The next notice requirement that everyone needs to be aware of is that it is incumbent upon anybody recording a lien against residential property to provide the notice to the homeowner within 10 days of recording of that lien. Now, we at Cooley Justice believe it's a best practice to provide anyone who is an owner of property with notice that a lien has been required. If the ultimate goal is to get paid, it benefits the contractor to let the owner know that a lien's been recorded against their property. We also believe that regardless of whether it's residential property or commercial property, the best practice is to serve that copy of that lien in a manner that you can track and prove that you've provided notice. The best option there, if you have an email address, is to send it via email to the owner and then to also provide a copy via regular US mail. Another option is certified mail return receipt requested, but it's best to be able to ultimately establish to a court that you did in fact provide the homeowner with notice of the lien.
And once you have your lien recorded, you're going to want to be able to support it with appropriate documentation. And what I mean by appropriate documentation is if there's an agreement that you have with the owner of the property or whoever's paying for the work that's signed, you're going to want to have that handy. It may sound obvious, but you really don't want to get pushed or show up when there's a fight on a lien and not have whatever agreement that you executed handy. I'll note that it's also possible to record a lien on an oral contract, but it's going to be far easier to support your position if there's a signed agreement. In that same vein, you're going to want to make sure that you have all of the invoices that were issued on the job, a record of when those invoices were issued. If you've received any payment, you're going to want to save that documentation as far as where the payment came from, when you received it, how much it was. And in addition, you're also going to want to save any photographs, emails, or text messages that were exchanged or created during the project. All of these different documents, photos, emails, text messages, have different timestamps on them. They show what work was done, when it was done, and who was at the project and when. And all of these little facts can be used to create a timeline and support your lien, support the fact that you filed timely, and keep everything moving in the direction that you want to so that you can get paid. Once you've gathered all of your documents and issued all of the appropriate notices, you're going to want to start pursuing payment. When you start pursuing payment, there's a few different strategies that are available to you. And in a moment here, I'll turn it over to Dan to walk through the wait and see approach and what a demand letter typically consists of and how it can be used to collect your lien. And I'll talk a little bit further about a lawsuit, but I'll leave it to Dan here to explain what we kind of call our wait and see approach on construction liens.
Now, a wait and see approach can be effective in the right situation, and the timing when it's effective is when perhaps you're not in a hurry for your money, or there's going to be an opportunity to essentially ensure payment without much work having to be done on your behalf or by your attorneys. But when we're taking the wait and see approach, the first thing that we need to do is to be mindful of the 2-year limitation on the enforceability of construction liens. Under Nebraska law, you only have 2 years from the date that the construction lien is recorded against the property to initiate a lawsuit to foreclose the construction lien. If you miss that 2-year deadline, then the lien becomes legally invalid and you have no right to recover, whether it's through a lawsuit or a subsequent sale of the property. So with keeping that 2-year lien in mind, the wait and see approach is really most valuable in the following situations. The first situation is when you have a good understanding that the owner is going to be selling the property soon. If the owner is going to be selling the property soon, then the lien will have to be paid at closing of that sale in order to transfer title, or the owner will have to put up a bond or a cash deposit with the court in order to sell the property. This wait and see approach allows you to either ensure that you're going to get paid at closing of a sale, or know that there is now cash or a bond that will ensure payment if you're successful in a foreclosure action, as opposed to having to get to the end of a foreclosure action and then attempt to work to sell that property at a private auction. The next circumstance where the wait and see approach is very effective is if you know that this is new construction and the owner is going to have to convert from a construction loan to permanent financing. The time when that loan is converted from the construction loan to the permanent financing will also require the title to be cleared up so that the permanent financing can have first priority on the project. And anybody providing permanent financing is going to require that the owner take care of any other liens that have been recorded in that interim period. So if you're working on a new piece of construction or a new construction project, know that it's incumbent upon you to get that lien recorded essentially as soon as possible if you believe you're not going to get paid. And certainly don't allow a material amount of time from substantial completion of the project to occur between the time when you leave the project and you record the lien. The last time that the wait and see approach can be very effective is if you know or have good reason to believe that the ultimate owner of the property will need to refinance for a better interest rate or for whatever other reason. If they're going to need to refinance, the same analysis that applies to converting from construction loan to permanent financing will apply. The last time where a wait and see approach may work is if you know that the owner has an aggressive lender and you have access to be able to provide that lender with a copy of the construction lien, perhaps as a courtesy copy on a demand letter, which we'll cover here soon, because there are certain loan documents where the recording of a lien can be a breach of the loan documents, where that lender, depending upon the lien amount, may force the owner to get it paid or suggest that they are going to accelerate the loan, and that can apply pressure that you might not otherwise be able to apply to get the lien paid. Now, if the wait and see approach is going to take too long or doesn't seem like an option, the next option is a demand letter. A demand letter has a lot of different options that are better than the wait and see approach, because it essentially shows the owner that you are ready to move and enforce your legal rights. Demand letters, we joke, can kind of scare people into paying or get people to pay when they might not otherwise pay, because they now have the opportunity to see the dots connected as to what happens if they don't pay. The demand letter can be particularly effective if you are a subcontractor on a project and you have a GC that's not paying you for some reason. At that point in time, you send the demand letter to both the owner and the general contractor, and you threaten to foreclose on the lien if you're not paid timely. that will oftentimes create a situation where the owner starts applying pressure to the general contractor to get you paid. Another benefit to a demand letter is it's more cost effective than a lawsuit. With contractors that we work with, we oftentimes come up with almost a form of a demand letter that is kind of at the right tone and it covers the right options that the contractor would like us to cover. And that demand letter may do such things as, identify the interest that our client would be entitled to recover, calculate the interest, but also agree to waive the interest if a timely payment is made. This serves as the demand letter acting as kind of the stick, but that offer to waive the interest, which might be substantial depending upon the amount of the lien, being the carrot to why you would get paid. The last reason why we really think demand letters are important, in addition to opening the lines of communication, is it provides the precursor to escalate things towards a lawsuit. While the demand letter is not required, you can then go in front of a judge or jury and say, I did everything in my power to avoid being here. I recorded a lien. I told them that if I can't get paid, I'm going to have to move forward with a lawsuit, and they chose not to pay me. And so the only real reason that we're here today is because the owner or the general contractor just would not release payment here. And so that gives you the ability to walk into court with some level of righteous indignation. And then if they don't respond to the demand letter, that's when we have to turn to a lawsuit, which I'll let Taylor cover.
So if you get forced into the situation where you have filed your lien, you haven't been able to recover, and you need to actually start foreclosing on that lien, you're going to start that process with a lawsuit. Now, a lawsuit is the step to, quote unquote, foreclose a lien, and this lawsuit would need to be initiated within 2 years of the lien being recorded. Now, we've mentioned this 2-year requirement a few times now, and that's because it is very important that you comply with it. If you wait to file suit until more than 2 years after your lien has been recorded, your lien is effectively worthless. What you're asking for when you foreclose on a lien is to effectively seek the judicial sale of the property that the work was performed on. What this means is that ideally you would get paid when the court orders that the property be sold. This is an extreme outcome that often doesn't happen because parties will resolve the dispute before then, but that is effectively the remedy that you're seeking, is a judicial sale of the property. Or if a bond is involved, then the lawsuit is going to be seeking payment from the bond company. And we'll kind of put a little caveat on this one. If the owner or the general contractor or whoever is refusing to provide payment ponies up and puts a bond in place, then you should be warned that you're probably going to be in for a fight. Those bonds are not cheap, so if somebody's going to pay to put one in place, they're probably going to resist your lien. And as we've kind of alluded to here, there's a few strengths and weaknesses to these different approaches. As Dan mentioned previously, liens can be very effective on new construction, particularly if you're able to get the lien recorded while the owner is under construction financing and will need to convert to permanent financing. This can result in you being paid when that conversion process happens, but liens are not always the easiest route or the best route to get payment. If you get forced into a lawsuit and you have to foreclose on your lien, the process to getting paid and the case working its way through the legal system is going to be slow and it is going to be expensive. This is something that everybody who's filing a lien or thinking about filing a lien should be aware of and should be part of their cost benefit analysis, because if you're able to get effectively 80 cents on the dollar for what you're owed without filing a lien and without going to court, that might be the more cost-effective approach, because you're going to lose a significant amount of time and you're going to spend a significant amount of resources if you have to go through the legal system and foreclose on a lien. An additional drawback to a lien is that a party can effectively wait out the enforceability of that lien. As we've mentioned numerous times now, there is a 2-year requirement for initiating the foreclosure of that lien. If somebody is going to hold on to property, if it's a residential property that the owner is going to sit on for several years, then the party can wait out your ability to foreclose on the lien and either force your hand or make your lien invalid. Another consideration that you should take in take into consideration is that your lien might not be first priority. Generally, liens are a first in time, first in right basis. But what that means is if you're filing your lien second to a mortgage being on the property or third to another lien being on the property, you're going to be second, third, or fourth in line, generally speaking, when it comes time to get paid. And now this is kind of where we'll pause, having run through a lot of information and see if there are any questions that we can answer for anyone with all that tossed out there. Yep. Should be seeing our contact information right now, and email addresses are a great way to get a hold of us if there are any questions that come up.
Great. So if that would be all, I mean, then there would be just a thank you for your time. Thank you very much.
Thank you.
Thank you.
Have a good one, everybody.